Hello, and welcome to our show, Crooked Doctors. We're live in the studio. Oh, this should be Jason. Hello? Hey, Jason, thanks for calling in. Let me put you through. Whoops, I think I just lost. Whoop. Shoot, I just lost Jason. He'll call us back. Sorry. What I'm going to do is I'm going to ask the engineers to move the phone right here because I know in the last couple episodes I missed a few phone calls. So what I'm going to do is, oh, here we go. Hi, Jason. Sorry about that.
Phone was charged, but it's not.
Okay. Well, you're on the air now.
Great. Fantastic.
You actually sound pretty good. Talk a little bit.
All right. This is the time to go ahead. Watch out for the cops. The heads on the roll.
Okay, so welcome to our show. Today is Friday, July 18th, 2014. And we've got Jason Berg calling in from New Jersey on the phone. And I apologize, I got a few phone calls and a few complaints. When we set up our new studio, you know that the studio here at Manhattan Neighborhood Network, we upgraded. And so we're still getting a few of the kinks out. So this is our phone right here. I'd like to ask the engineer if he could put the phone here a little bit with an extra arm so I can see it, because the phone was behind me. And as I get into the content of the show, I apologize to the few people who called in the last few weeks, and I didn't see that the green buttons were lining up here so that your phone calls can come through. So if you'd like to give us a call, we're at 212 245-7273. That's our call-in number right here, 212-245-7273, and you can ask a question. We got Jason Berg on the phone. We've got Josh Valinsky in the studio with us. And I got a couple questions, so I'm going to answer them, okay? And what we're looking at is overall, what we're asking is, when people go to court, whether it's landlord-tenant court, whether it's criminal court, whether it's federal court, there's only a few points of control. If we give out a few pieces of information, we can stop a lot of the public corruption. So I've been victimized. Jason is trying to help people in Jersey City who've been victimized. And the point of this is not to parade out, how we've been taken advantage of, but how do you change the system so for all the people who come after us, they won't be victimized. So, ladies and gentlemen, this is the enemy. Listen up. This is the enemy, and this is how you stop them. Okay? So that's what we're doing today. Okay, Jason?
Correct.
This is. Go ahead.
No, damn it. This ain't fantastic. I agree.
So this is the briefing. Listen up. Okay? So here we go. I'm going to switch the camera view right now. And, whoops, sorry. Okay, so this is the enemy and how to stop them. All right, and it's very simple. You with me, Josh?
Mm-hmm. I'm with you too.
Okay, here we go, Jason. So basically, there's only 5 points of control. So you're going to go into the courtroom where people are going to try to hurt you, and there's only 5 points of control. There's only 5 things you really need to worry about, and these are very effective. How do I know? Because I field tested them, and then another member of NLA, or National Liberty Alliance, also field tested some of this, and we're still field testing this, okay? So basically,
we know it works. It's not field testing because they've already succeeded.
Well, that's true, but we're still field testing because we're taking out a few of the kinks. But basically, you're in the courtroom, okay? So, if you want, and I discussed this with Joe Barton too, and Paula Gloria. Let me just fix this a little bit because it's got a little shadow on it. Hold on. Okay. Thank you for your patience. So here we go. You're in the courtroom. Let me just get my camera view in a little bit. All right. Now, there's only a few things that you really need to know. You're in the courtroom, right? And you're facing the judge. And you know the judge is going to pull, dirty tricks and make stuff up. You're in an admiralty maritime court. They're going to use statutes and codes and all kinds of stuff. So you don't worry about that. Because if the judge tries any dirty tricks, and this has been used successfully in prosecuting judges and stopping public corruption, this statute, failure to provide honest service. So 18 USC section 1346, and you can Google it out there if you're out there listening, is failure to provide honest service. So you can prosecute the judge. You can become a whistleblower. If you stop anything, if you stop any kind of corruption, you can collect 25% of any of the monies that you recover as a whistleblower. But basically, you're looking at a judge or any corrupt official, so any elected official, the comptroller's office, anybody you're dealing with in a corrupt city or state or federal government can be put a stop to with failure to provide honest service. And this statute, 18 U.S.C. 1346, was used successfully to prosecute judges in a big scandal in Pennsylvania. Judges were sending thousands of young people into detention centers where they got a kickback. So judges are successfully prosecuted. Now, they want you to think that they have absolute immunity. If you're in criminal court, they want you to think that the prosecutor has absolute immunity. They do not. If they're violating your civil rights, that is not a judicial act. Okay, so that's just because a judge is sitting in his jurisdiction and he decides to violate someone's, like me, constitutionally protected right, that does not mean he's doing a judicial act that deserves immunity. Judges only get qualified immunity. So you can hold judges accountable and put a stop to a lot of their corruption. They do not have absolute immunity. Now, these little kings and queens would like you to believe that they have absolute immunity because they can fool you, but they don't. And the prosecutor who's trying to prosecute you will try to convince you that he or she has absolute immunity. They don't. So you put a stop to them with 18 U.S.C. 1346, failure to provide honest service. Now, if they can't get you any other way, right, there's only 5 points of control in the system. If they can't get you any other way, if they can't criminally convict you, they're bringing criminal charges against you, if they bring you into landlord-tenant court or in any civil action, and the judge decides he wants to get you, and this is part of our Crooked Doctors theme, what the judge will do is he'll do a court-ordered psychiatric exam, okay? It don't matter what the crooked judge ordered, okay? In New York, it's called a 730 hearing, I believe. So, you know, a lot of people get intimidated. There's one person I know who was started a civil action. The judge did a court-ordered psychiatric exam, and she never went back to court because she was afraid. I'm like, no, there's nothing to be afraid of. You invoke New York Education Law, Section 6530, which is misconduct on the part of physicians. Subsection 16 says the doctors have to know the law. There's no excuse for ignorance of the law, and they have to fully comply. Subsection 26 says, without your consent, without authorization, they are performing professional services that have not been duly authorized by the patient. So it don't matter that the crooked judge ordered the crooked psychiatrist, the crooked doctor, to give you a court-ordered psychiatric exam, because when you go into the room with that crooked psychiatrist, you say, no, doctor, I am not giving you my consent, I'm refusing. And if you try to create false records or offer an opinion or say anything about me, I will take you to your licensing board and sue you under New York Education Law, Section 6530, which governs the misconduct on the part of physicians, okay? So now you put it, there's only 5 points of control in this system. You put a stop to the judge with failure to provide honest service. You put a stop to the court-ordered psychiatric exam by invoking New York Education Law, which governs the misconduct on the part of physicians. So you put a stop to that. Your attorney turns out to be a big fat liar because he's crooked. Their attorney turns out to be a big fat liar. You don't worry, because under New York Judicial Law, Section 487, this is the law that governs misconduct on the part of attorneys. So you say, yeah, go ahead and try it. I'll sue you for triple damages, and it's a misdemeanor, so I'll get you for criminal conduct. So you put a stop to their attorney, and you put a stop to your attorney if they engage in any deceit or collusion. So go ahead and lie, make my day, right? Now, you know the transcript is a point of control, all right? And you know they're going to change the transcript. Now, when this first happened to me, I thought I was crazy until I started talking to Rob Kozowski, a pro bono attorney at the Nassau County Civic Association, and other attorneys, and they're like, you watch. Keywords and phrases in that transcript are going to be changed. You watch when you order that transcript. Now, you all out there in the viewing audience think that, you know, we're all taken advantage of. You think that transcript is sacrosanct, like it's protected like Fort Knox. It's not, okay? The court reporter is this is just some entrepreneurial job. They could take that audio tape home, listen to it in their living room, type it up. So you watch, anytime you get that transcript and you pay for this, keywords and phrases will be changed. So go ahead, Jason.
Well, you can get the audio.
Yeah, you're coming in a little bit garbled, but I know what your question is. And the question that Jason asked was, you can get an audio tape of the proceedings. Yes, you can. So you can order an audio tape of the proceedings and to protect yourself, but you know that's going to come in garbled, right? And keywords and phrases will be mysteriously missing, because remember, this is all in their control.
Well, wouldn't that judge also be responsible for not be giving you fair services?
True, but the person who does the transcript is the court reporter. So
yeah,
yes.
But the equipment that's in there, you pay for as a taxpayer, and you're supposed to get quality representation of the transcripts. Audio
you
and
are.
Video.
You are. Well, not all courts. Very few courts have video. We're working on trying to get independent cameras in the courtroom. But you're quite right, because what you're trying to say is that if you're also the statute of failure to provide honest service or honest service fraud also, and you're quite right, applies to the court reporter and anybody who touches that audio tape or the transcript. So yes, what Jason's trying to bring out, and he did because he's very insightful, is that yes, this statute also applies to the court reporter and whoever's handling the transcript. Failure to provide honest service is a very broad statute, and it applies to just about everybody, even in the private sector. So that's why federal prosecutors really like this statute. Defense attorneys really hate it, and Judge Scalia.
Question, is that a statute or a code?
It's a statute of code. It's a
statute of New York State.
It's a federal law, 18 U.S.C. The title.
Well, this is point of information. Anything federal is a code. Anything state is a statute.
Oh, okay.
Correction.
Go ahead.
Lydia.
Yeah.
What impact does the fact that the judge is also supposed to be administrating justice and is also supposed to challenge the validity of questions by lawyers and all of that? What impact does what you're saying have on that function of the judge as an administrator of law?
Well, he's supposed to be fair, and he's supposed to make sure but we're talking about practical reality. These people are crooked, corrupt. You know you're going in there, and you know that they own the system, and it's stacked against you. So what we're doing is what impact is we all know the judges are corrupt. I mean, think about it. If you were the Bar Association, would you want to put an independently minded, morally strong person on? No, you want the worst alcoholic, the weakest character you could find, because that's how you control the judge. Right? This is not, our court system has nothing to do with truth and justice. It's about power. So what we're showing you today, and listen up, this is the briefing, this is how you protect yourself from these abuses of power. Okay? So the transcript, which is beyond your control, and you know they're going to change it, you can get the audio tape, but it'll also be garbled in keywords and phrases. So that's why your allies are in the courtroom. Remember, in past episodes, when we went into court, we'd have court support buttons. We want the judge to know that we're there. We carry great big legal pads, and we take notes. And if anything really bad happens, we after the court proceeding, you get affidavits and you submit them to U.S. attorneys. And remember, unrefuted affidavits must be accepted as evidence. Okay, so these are the 5 points of control. You can control the judge. You can control the court-ordered psych exam because they're going to practice Soviet psychiatry on you, right? Psychiatry as a political weapon. You compensate for the transcript or the audio tapes being changed by having your allies in the courtroom. And there's a few things we're not going to talk about on TV, but we backed ourselves up a few other ways too to make sure that that transcript and that audio tape better comport with what went on, or we gotcha. And you control your dishonest attorney and their dishonest attorney with New York Judicial Law, Section 487. And so those are the obvious points of control. But this is in a maritime admiralty court, so you give them enough rope to hang themselves, and then you switch up the game on them by invoking common law. Once you invoke common law and you open up you say, you know something, I've played enough of your games. I've let you take advantage of me enough. I just woke up that you people lied to me, and I'm in a maritime admiralty court. Now I'm going to open up a common law land court of record. I'm going to invoke common law, and the job of the judge, you don't have a judge now, you have a magistrate. The tribunal is the decision-making body is not the judge anymore. It's a jury of your peers, and they understand exactly what's going on. And the judge, who's not a judge anymore, is just a magistrate's job is just to make sure that there's enough decorum in the courtroom for you to present your evidence. Okay, so that's what we're working on. That should answer some questions. Jason, you have any comments you'd like to make?
No. Hey.
Okay.
All
right,
is
so
that when you come in for the common law, you ask a simple question. The judge will say, do you understand the charges against you? You say, no. He'll get very upset. You ask the question, Your Honor, is this a civil court or a admiralty court? And he says, it's a civil court. Well, Your Honor, who's the victim here? Well, the judge will say, the officer said, you did X, Y, Z. Your Honor, the state can't be a victim. Therefore, I want these charges thrown out, and I want, as a plaintiff, to be paid for you wasting my time.
Okay, so what you're talking about is when you're dragged into maritime admiralty court, or when you're dragged into what we think is a court, and you got the judge who's going to be the decision maker or the decider. Jason is telling you, and you can learn on the National Liberty Alliance website if you sign up if you register with the website, and you can read about how you can invoke common law, and common law is well established in New York State. How you can invoke common law. In common law, the decider, the decision maker, is not the judge. The judge is just a magistrate to make sure that there's enough decorum going on. The deciders, or the tribunal, is a jury of your peers. So when you come in and you say, they drag you in for criminal charges, and you say, no, I don't understand. You've got a maritime admiralty court here. I'm going to open up a common law land court of record. I want audio tapes of everything that's going on. I want videotapes if possible. And you are not going to impose your laws on me because they don't operate in a common law court. So when you switch it up like that, go ahead.
It really comes out of the Fifth Amendment. Anything that is over $20, $25, there must be a trial. You are not getting a due process when you have a judge, magistrate, sitting there dictating what his laws are. And therefore, you're being violated of the Fifth Amendment to have a fair trial.
I don't think you're talking about you're talking about the Fifth Amendment to the Constitution. I think you're talking about the Seventh Amendment. I'm going to show this right now. Hold on.
No, it's the Fifth. You're entitled to this due process.
Oh, yeah. And actually, I brought it up here. Hold on. Just 1 second. Okay, here we go. So, whoa. Yeah, it's the Fifth Amendment. You have the right to due process that you shall. So, if you're brought into court, yes, this is your Fifth Amendment constitutionally protected right to due process. You cannot be deprived of life, liberty, property without due process, and so you got your Fifth Amendment. You're right here in criminal proceedings. You have the Sixth Amendment, which also says that this is also your constitutional right too. So you have the right to effective assistance of counsel. Depending on whether you're in a civil court, you're prosecuting a case to try to get some restitution, or if you're in a criminal court. I think what you were referring to, Jason, was the Seventh Amendment, where it says if the value in controversy it shall exceed $20, then you have the right to trial by jury. So I think you're really referring to the Seventh Amendment, trial by jury in civil cases. So if you invoke common law, let's say you go to court and someone ripped you off. If you invoke common law, it's not the judge who's the decider now, okay? Because the judge is just a magistrate, and the tribunal, or the people who are making the decisions, are the common law jury that you put in place. So if you're better off, when I go to court, if you're better off. When I go to civil and to court, my case is actually going to turn criminal. But if you're better off, when I go out into the field, for example, and I start to explain to people, because we field tested some of the points of control to stop the public corruption. So we field tested a little flyering campaign where we say, where we're putting out some of this information, where we photocopy the law and we hand it out to people in handbills. So when I start explaining for example, for you, Josh, here's how they falsified the financial information to steal money from me. You understand it. You're the common man in the street. Well, you're a little more well-educated than the common man in the street. But, if I go out into the street and I start handbilling to people and I say, this is how my medical school falsified financial information to steal money from me, and this is how it's hurting me, they understand. So I don't have to get jerked around with the crooked judge. They're going to misconstrue the statutes. They're going to throw out my documents. They're going to change my documents. They're going to pull they're going to do statute of limitations issues. They're going to do all this stuff, all of which doesn't count. I'm like, okay, now you've pushed my buttons enough. I'm sick and tired of being taken advantage of. I've given you enough rope for you to hang yourself, particularly in my case. So now I'm going to, you've taken advantage of me enough. I'm going to now invoke common law. I'm going to change this to a common law land court of record where me and my peers are the sovereigns. The judge is just a magistrate. Their job is just to make sure there's enough public decorum so that I can present my case. But I'm presenting my case to people like Josh Volinsky and Jason Berg.
Yeah.
Go ahead. What did you want to ask?
Well, I remember LaGuardia, Fiorello LaGuardia was a magistrate. They never called him a judge. But I want to say, you may have to, at the very beginning, tell them that you do not accept the authority of Roman law.
There you
or
go.
at the court. You may have to tell them that, because the judge may say, well, there is nothing I can do for you. You'll have to go before another judge or another court.
No, you go into that court and you say, you're hoodwinking us. You've dragged us into this maritime admiralty court where you're going to invoke your statutes and your codes and all the little games that you're playing, because you don't want us to know about common law. Because common law is, do you have an injured party? Yes, me, for example. Can the injured party explain in simple common term, simple language what happened? Yes, my medical school falsified records to steal money from me, and they're ruining my life today. And then I got a bunch of people like you who's like, oh, well, that's wrong. Let's put a stop to it. Could it be any easier? Of course it couldn't be any easier. Do they want you to know? No, they don't want you to know that you're in charge of your courts. Because this is all about power.
It's all, I was saying, you're not, ignorance of the law doesn't preclude you from obeying it. That's their codes and statutes and ordinances. You, as a sovereign person, don't have to comply because you're not incorporated and you're not an employee of the establishment the government.
Exactly. So with just these few pieces of information,
Yeah.
you can put a stop to a lot of the public corruption. So the point of this show, did you want to say something? Go ahead.
Yeah, you remember what the judge said to Paula and to Joe Barton? She said, "I'm too busy to decide anything concerning your case today."
No, that's not what she
then
did. What she
what
did was
What
Paula,
did she do?
Paula, what a judge wants to do, and this is another dirty trick. What a judge wants to do is they always want to do everything on the papers. Okay, what the last thing the judge wants to do, first of all, the judge isn't reading your. First of all, let me go back a couple steps. If you're going to go in and do this, you're representing yourself. You go in, you put in your papers. You have no idea what that judge is seeing. I guarantee you, you do not control that system. The judge is not seeing any of your arguments. Your paperwork goes in there. They're throwing out documents. They're changing stuff. This is not my personal opinion. The courts in Queens are notorious for this.
And
go ahead.
just a point of information,
Mhm.
anytime they remove any materials from your docket, they are performing a felony, which they can go to jail for sometimes even up to 20 years.
Yeah, good luck. Yeah, good luck holding them accountable. And I mean, these are the dirty tricks. That's why we're telling the audience this is how you protect yourself. Okay, they're going to refuse to accept your documents. You don't know. They're going to try to intimidate you with your ignorance. That's why you always use simple common sense. That's why I tell the people in my the men and women in my tenants association. They're going to try to razzle dazzle you and use your ignorance against you. The law is about, and the courts are about, simple common sense, right? What would a reasonable man do? The reasonable man test. So if you don't know what to do, take a deep breath, calm down, and just do what a reasonable person would do. Don't let them try to take advantage of you, right? So what you do is, so you're putting your paperwork in. You know they're going to throw out your documents. You know they're going to change them. So the flow of information to what you think is the decider, the decision maker, the judge, the flow of information to that gatekeeper is manipulated. Now, this whole thing is about power and the abuse of power and how to take your power back and how to stop the abuse of power, right?
Well, it goes with that statement I have. I have no problem with authority. But when authority becomes abusive, it's time to check its muzzle at the door. But also in the fact, if you're going to file your documents, make sure you get their seal at the same time you give them theirs. So you have two documents, and they will be certifying your copy as they are certifying theirs.
Exactly. At every point along the way, you should be thinking, what are they going to do to shut me down? Because you know they're going to do it, okay?
Right.
So you know that this whole system is corrupt, and these are the key points of control. So you know what's going to happen. In fact, William Doherty and I submitted in Jersey, and when he was fighting his battles in Jersey, we submitted a 14-page motion. The clerks threw 13 pages away because they decided that the judge only needed to see the one page that they decided. Okay, that's a crime. So you got
What court was that? Was that municipal court in Jersey City?
No, this was in 595 Newark Avenue.
Oh, the Superior Court of Article 3 and Inferior Court.
No, that's the district court. The Article 3 courts are federal district courts. We were in the state court in Jersey, 595 Newark Avenue.
Yeah, well, that's also a Article 3 and Inferior Court stated by the Constitution.
No, the Article 3 courts are district courts, but we don't have to go into all that stuff.
Right.
There's state courts and federal courts.
And one thing I should say about courts, all these courts should be free. It's for the people. It's not for profiteering, and these people are doing it. The reason why our system is corrupt is because everyone is getting a kickback.
Yeah, it's fueled by greed and money. I mean, it's just they're charging fees, and it's just another form of taxation. So, for example, you're telling me that a friend of mine was going to medical school out in Stony Brook. They got nothing but land out in Stony Brook, but they made these parking lots, and now they collect a lot of fees and parking tickets, right? So you're sitting there and you're seeing nothing but land, plenty of places to park, but everybody's getting parking tickets. Of course, it's just a way to milk you for money. At Rikers Island, where I was illegally incarcerated, they make you pay for your own incarceration in the surcharge. So if you're convicted, and a lot of the ladies were upset, there's a like $300-400 surcharge. So they'll get these jobs, doing the jobs in prison. The money all gets stolen. They never get paid because they're always paying the surcharge. So one of the first battles that I won in Rikers Island, and I'm winning this from Rikers Island, is I got some of the women the inmates to cooperate with me, and we beat the surcharge. So I actually made legal history from Rikers Island where we beat the surcharge, and I had a whole string of cases lined up. And if I had success in one case after another, if I had won all those cases, I would have effectively stopped the surcharge, which would have cost the city several $1 million. So they didn't want that to happen. They could see that it was happening after I won my first case. And I'll bring in the details of that. They got such a kick out of me in prison. After I made legal history in prison, I started and everybody out there will know I'm telling the truth, because some of the women that I was incarcerated with have seen me on TV, and they stopped me when I went out. One of them was in Jersey, and she saw me and she waved to me. She was like, "We saw you on TV." So we actually were incarcerated together in one of the dorm situations, and I saw her out in Jersey City after we were both released. But they'll know I'm telling the truth, because after I made legal history from Rikers, beating the surcharge, I did the Inmate City newsletter, where I shared that victory with all the inmates. And because there was no computers or typing, I had to do my first edition by hand. So the Inmate City newsletter beat the surcharge. Here's how. They loved it. They passed it hand to hand to hand to hand. That's when they realized we better put Lydia in the mental observation board and tell her to shut up, because if she's successful with these cases, I had set up the cases pretty well. We had the help of some legal people, and I'd set up the cases pretty well. If I had won the first, the second, the third, fourth cases that I had all set up, that would have stopped the surcharge and cost the city several $1 million. So it's the power of the purse to shut them down.
Lydia and Jason, one of the most corrupt courts that I've ever done before was the Environmental Control Board. And what they essentially were doing were bringing artists and book peddlers to court, violating their First Amendment rights, saying that because they took over sidewalk space, they had a right to give us fines. And I wish that I had fought and get the money back for all those fines. Because they also violated my constitutional rights. But even if a homeless person put out a pair of shoes in front of themselves and tried to sell those shoes, they were brought before the Environmental Control Board, which was outrageous, because in New York City, when they sell Christmas trees, they can take many square yards of space without any violations. And some homeless person selling their shoes were brought before the Environmental Control Board and charged a substantial fine.
Isn't that interesting how they have different rules for different people?
Well, isn't that called hypocrisy?
And under, let's go back to...
Color of law.
Let's go back to
well, Josh, I think any fraud you can go back on. There's no statute of limitations, because they're using their court to rob you.
Yeah, absolutely.
If you can show that there was a fraud upon the court, or you can show that anyone lied or that kind of stuff, you may be able to go back and reopen it. But remember, you got this very handy-dandy little statute that we went over today, which is failure to provide honest service. So you can use that to stop a lot of the public corruption. So this is, right, this is the enemy and how to stop them with 5 points of control. But yes, they do use the power of the purse to try to, shut you down, other forms of taxation, like we don't pay enough taxation, so they're always trying to figure out a way to
We're not even supposed to pay taxes. Why are we? Prior to 1913, we weren't paying anything. Only corporations were. Now, corporations now are paying less or nothing than the people.
And again, that's because we don't participate in our government.
Well,
we
even if we do, they try to stop us. You vote for someone for being good, they screw us. You petition your government, they screw us. And when you speak against your government, now Holder wants to go after people criticizing Hale, Hitler, Obama.
Yeah. So one of the reasons why they get away with all of this is because we've allowed it to happen. This is not a lot to read. If you read your Constitution and you knew the few points of control that I've put out and right here, you can put a stop to a lot of the harm. They've dumbed us down. Okay, they want us to be sheep because remember, this is all power and control issues, right? Mm-hmm. So if you were, this corrupt guild of attorneys, right, would you want the population to know that, that they could represent themselves and handle their own business? No, you become like a secret society, like a secret priesthood. And you've got all these little, you don't share your knowledge. That's directly against everything I was trained as a scientist, because information is supposed to be readily available, and everything you do as a scientist is supposed to be done in an above-board, open fashion. So the reason why they get away with this, I'll finish in just 1 second. The reason why they get away with this for medical school students is because we're not thinking like this. We're not thinking about the deceptive practices, the points of control. Everything we do as scientists is done in an open, above-board fashion according to the scientific method. By the time you figure out that someone like Martin Bachstein, for example, is rigging the system to destroy your life, you're already on that railroad train out of there, right?
Well, you got to understand, the bar, the British regulatory group, makes money on confusion. They say that you need to know the law, but the law, in order to be a lawyer, you have to be a juvenile, mentally incompetent, or business. Well, majority people are being railroaded because they're told that you need a person who knows the law. The law of the land is common law.
Correct.
Period.
So let me go back to this. And the law of the land is the Constitution. This is not hard to read. Okay, you can go through. This should be the book that every child should grow up reading the Constitution. Yeah. Well, they should know it best, because if you just know this little book right here, the U.S. Constitution, nobody can take advantage of you. All right, so you don't need to know all the statutes and codes. And once they start with all the statutes and codes, if you invoke common law, right? If you invoke common law, right, they can't. Then it's very simple, because you're an injured party. You're explaining your injury to a group of your peers, and certainly if your family and friends can understand what happened to you, then a group of your peers or your church group or synagogue group, or they can understand. So if you invoke common law, you don't do the statutes and codes. You don't do the statutes limitations. You don't do all that maritime admiralty court where the judge is making the decisions. You and the tribunal is a group of your peers that you're explaining what happened to you, and you're asking for restitution.
Yeah, what is the significance of being a victim in the court? What's the significance of that?
That's a very good question. I'm glad you asked that. Yeah. That is very good. And I'll tell you why, because we actually had this discussion because we had a little study group last night. That's actually a very, very good question, and I'll tell you right now. And it buys into. Hold on, let me just whip this out. Article 3 of the Constitution. We were discussing this. And it also answers a question about the Bob Jones University case. Let me just adjust the camera here for 1 second. So here we go. Jason's talking about Article 3. Article 3 of the Constitution is how do you set up the courts, right? But right here, this is when you go into federal court. Now, federal courts are courts of limited jurisdiction, okay? So you need to, when you go into a federal court, you need to explain to the judge why you're there. This is called subject matter jurisdiction, okay? Federal courts are limited, courts of limited jurisdiction. They don't hear everything. They just hear controversies that have these particular characteristics. Now, so for example, you know, they're only going to hear cases where there's a controversy between 2 or more states. So if New York wants to sue New Jersey, they would have subject matter jurisdiction because there's a real controversy between 2 or more states of the union, and they would go into a federal court to duke it out. Now, this word right here, controversy, okay, there has to be a real person with a real injury. So Josh just asked something very insightful because I'm gonna highlight this, controversy, okay? There has to be a real person, controversy, all right? The reason why this is so important is because in the Bob Jones University case that I've spoken of before, right? They made up, okay? It was completely hypothetical. There was no real person. So when the federal government, with a whole bunch of groups who were targeting this Southern Evangelistic Christian School, decided to go after Bob Jones University, there was no real controversy because what they did was they claimed it was a witch hunt. And they claimed that Bob Jones University was racist, and they pulled words and phrases out of Bob Jones University's student guide. And in their student handbook, which is probably, down south it's very common that there are laws on the books that are never enforced, but they've been around and they tend to reflect the slavery times and the racism of the South, but these laws were never taken off the books. So they went through Bob Jones University's student handbook, and there was a prohibition that said that students of different races couldn't date each other, even though Bob Jones University allowed students of different races, married students of different races into the school. They did not allow for interracial dating. Now, most of that's pretty, I think, silly, because if you're sitting in a library and you are studying and you say to a person of a different race who's studying next to you, let's go out and get a pizza and a soda, you might be on a date. You know, I don't think the school officials were checking to this degree. And in fact, there wasn't a real victim of Bob Jones University. A student did not come forward and say in a real controversy. It was completely theoretical, completely made up because it was a witch hunt. No student came forward and said.
And then add that too.
There was no student that came forward and said, I dated outside of my race. School officials found out. Wait, Jason, let me just finish this, because there was no real controversy. So there was no student that came forward in the Bob Jones University case, and this went to the Supreme Court. So all these lawyers did not point out that, hey, I don't have a real victim here. Okay, no student came forward and said, I was a student at Bob Jones University. I dated outside of my race. School officials found out. I was subjected to student discipline, up to including expulsion. I was expelled, and now my life is ruined, and I must sue Bob Jones University. There's no real victim in the Bob Jones University case. I keep saying, where's the victim? So they used that to have the federal government and other groups go after Bob Jones University, revoke their tax exemption, and again, that was the first thing, but then they fabricated, wholesale made up, that if you were discriminatory, if you discriminated, you were not charitable, and if you were not charitable, then your tax exemption was revoked. So they fabricated that too. This is how dangerous these courts are. Okay.
Well, my question here is,
sure.
What year was that court against Jones University?
Bob Jones University, the suit against Bob Jones University was about 30, 40 years ago. 40, 50 years ago. It was in the late 60s, early 70s. It dragged on to the 80s. And I remember quite well the Jerry Falwell interviews. And what bothered them when I called them was I started asking these questions, and their attorneys were a little miffed. Because can you imagine if you had spent so much money to take your case to the Supreme Court, and a little schmuck like Lydia Radin comes by and says, "Excuse me, but the attorneys are not asking the proper questions here." They were a little irritated.
Well, again, your ignorance doesn't show up until stupidity acts on you.
So in the Bob Jones University case, they were a Southern evangelistic school. What they wanted to do was choke this school. They wanted to stop this school. They wanted to end this school. In fact, Bob Jones University, the way it played out, was the victim of racism. They were not the racists, although racism is rampant in the South. In this particular case, Bob Jones University was the victim. And they, just because they started screaming racism, they were painted with this black brush. So there was no real victim. The ruling at the Supreme Court level, and you have to read the William Rehnquist's dissenting opinion, they fabricated it. And so basically was what they really wanted was to revoke Bob Jones University's tax exemption, not so the school wouldn't pay taxes, although that was a good side benefit, but so that the rich donors who were donating to the school would not get the benefit. So if you scared off the donors, then they hoped the school would die. Okay, so they were trying to kill Bob Jones. That's what they were trying to do.
And did they kill the university?
Yes. Well, no. What happened was their tax exemption was revoked, even though it was fabricated and made up, and now declared to be the law of the land. And then what the IRS did is the IRS sent a letter, late 60s, early 70s, going to the late 70s, and they sent a letter to all the universities, including Yeshiva University. And they told Yeshiva University and all the schools, if you discriminate, we're going to pull your tax exemption. Now, Yeshiva University, I'm going to finish in 1 minute, had been living in fear for going on 50 years because they knew they discriminated. They were an Orthodox Jewish school. They knew they were pulling off a massive fraud, and they were just waiting for the day when someone like Lydia Radin would show up and figure it out and say, wait a minute, there's something very wrong here. Because what's happening here is Yeshiva University discriminates on the basis of religion. Do you see anybody pulling their tax exemption? No.
Because it's Jewish favoritism.
So the problem here is, as I've pointed out, is that our federal government is discriminating on an institutional scale. Why? Okay? So this is wrong. Okay, these are not honest courts and a just court system. This is abuse of power. That's wrong.
And it's totally, you know it's wrong. But again, it's like the IRS going against the Tea Party and also calling them terrorists.
Thank you. Thank you, because when they brought this out, and we are going to have to go, Jason, you, me, and the rest of the common law group, we're going to have to go down to Washington and say, hey, wait a minute, guys. The IRS has been discriminating. Bob Jones University is an example for 50 years. The Tea Party is not the first victim of the power of the purse, of the IRS discriminatory behavior. This has been going on for a while. We have to call the Tea Party. Jason, call the Tea Party and say, listen, have you heard about Bob Jones? Any conservative group that doesn't like what the progressives are doing, all of a sudden you find yourself targeted. This is not new to the Tea Party. Bob Jones University has absorbed this racism imposed on us by our federal government. Our federal government is dangerous.
Oh, actually, what they did with all the paperwork, they did a fraud, mail fraud. And that's $1 million plus 30 years imprisonment. And again, Lydia, you're no schmuck. You're an intelligent person who knows what's going on. And because the lawyers have no vision, they are morons. But they're less than what they should be.
Well, thank you very much, Jason. The mission of an attorney, we're always, I was talking to some of the leadership and National Liberty Alliance last night, we have a little study group where we call in and we ask questions and we're given reading assignments and stuff. And we're always surprised because we work so hard. I mean, we're writing the stuff till our fingers bleed. We're reading the stuff till our eyes bleed, and we're always surprised that the attorney's legal work is so bad. It's like they don't, because the job of an attorney is not to win your case. What's the job of the attorney? To milk
make money
you of
for
money.
himself.
Exactly. The only thing they care about is how do I play you to line my pockets. And when you look at their legal work, you're surprised at how bad it is because that's not where their attention is.
Well, again, they won't be able to create the income if they solve the problem immediately. You don't need a lawyer for anything unless you are adolescent or you're incompetent.
Right, because you can invoke common law. Now, we're going to go over these points of control, very briefly every
Are
week.
there any points of control over the other officers of the court,
Yes.
like the lawyers and even the security? What about the court officers? They can look at anybody and they say, take off your hat, as
That's
if,
that, and
you
that's status quo.
Well, yeah, because remember, as Jason pointed out earlier in the broadcast, can failure to provide honest service be used to control the court reporter? Of course, this handy-dandy little statute here, failure to provide honest service, is very good because you can use it in a variety of contexts. And
Well,
that's
again, that's New York State. But again,
No.
This is
This is a code. You were right. The 18 USC Section 1346. That's a federal law. That's a code. This is 18 is Title 18. Title 18 is the the criminal code. This is how you prosecute someone with federal law. So yeah, failure to provide honest service. Now, Judge Scalia on the Supreme Court doesn't like this because he says it's so broad as to be unconstitutional, and there have been some Supreme Court cases that have limited this, but you can see that the prosecutors really love this because it's so broad. You can provide it in a variety of contexts. But yeah, there's you asked such good questions to you two guys. Got to be on my toes for you two. But
Well,
yeah, this
again, just to add in a little bit more, what Josh said about the hat, it's status quo. Now, when I was in 595 Newark Avenue, I was giving out free literature to educate people about their constitutional rights and the common law grand jury. This individual said, well, you can't solicit this in this building. And I kept on asking a simple question. Where is your authority from code, statutes, or ordinance that gives you the power to tell me that I can't distribute my information? He couldn't find it. He even communicated with the morons at Hudson County Administration Building, and they couldn't find the law. It was only a ruling. And the real thing here is a ruling that only applies to people who are employees of the establishment or who are corporations. So by them telling me and almost threatening to arrest me, that was a violation of my civil rights to freedom of speech.
It may well be, and I don't know enough to comment, but I can tell you this: when your civil rights are violated, and you're denied equal protection of the law, you do have a federal right. You can create a federal right to go into court and sue, which we'll get to later. Now, what Jason asked me is, would I put this into writing so that we could put it up on Blogger, for example, which is free? It doesn't cost a lot to challenge authority, right? Blogger is free. And would I write this up and give it to the National Liberty Alliance so other people can use it? Yes. Jason, we've got about less than 4 minutes, and I know you wanted to help Manhattan City Councilwoman Helen Rosenthal, and we're a big proponent of education. So Josh asked me once again, I'm going to show the flyer, and then you want to talk about it?
Yes.
Jason, Manhattan City Councilwoman Helen Rosenthal is having an event on July 23rd, and we promised that we would help her advertise it,
Oh,
you know,
good.
promote it and tell people to come. We must be having a positive effect because some people from the Manhattan Borough President's Office said that they've noticed an increase in attendance, and they definitely want people to come to this to
Good.
learn. So I'm going to show that flyer now. Is that okay, Jason?
Hey, it's your show. I'm just here as your co-host.
Yes.
Okay, so we're looking at now. Josh, you want to talk us through this a little?
Yes. Well, this is going to be the first of many meetings on the first Wednesday of every month, starting in October. But we're having a special one on the 23rd, July 23rd, from 6 to 10 p.m. at Goddard Riverside.
Wait, no,
Give
leave it right here. It's good.
At Goddard Riverside,
Side.
which is at 88th Street and Columbus Avenue.
Right.
And you come in, the Urban Justice Center will be there. The main topic will be the new SCREE and DREE laws,
This is rental assistance. So this is
new income levels,
where SCREE is SCREE
29,000.
SCREE is for senior citizens, and DREE is for disabled people. These are rental assistance programs. So even if your rent goes up, the amount that you will have to pay will not go up. So this is really important. And the best thing about this is that now we've just spent all this time dissing
The
attorneys.
income level went up to 29,000.
Yeah, but what's going to, I have to apologize to the Urban Justice Center because their attorneys are actually very good. But if you come to this, not only will there be a lecture at which you can stop and ask questions about SCREE, which is for senior
That's
citizens, and DREE for disabled people, but you can actually have a private consultation
Yes.
with a free attorney, okay? So whatever and it doesn't have to be about SCREE or DREE, it could be about anything. So if you're having any problems with your landlord, just come to this free housing clinic. It's Wednesday, July 23rd from 6 to 8 p.m. at the Goddard Riverside Community Center. And you can talk to a free attorney. I sat down with a free attorney the last time they did this for 40 minutes and they checked me out. They're like, they had pretty nice things to say. They're like, you know about 80% of your stuff in landlord-tenant court.
Yeah.
And so that was pretty good. But the things that I didn't know, they told me. So you can get to come and talk to a free attorney.
Yeah.
You can have a free consultation privately in another room. If you have any problems with your landlord, if you just want to learn about what rights you have as a senior citizen to make sure your rent stays stable under a SCREE program, it's a senior citizens program to keep your rent stable, or if you're disabled and under DREE for disabled people, these will keep your rent, the amount that you contribute to your rent, the same, even if the rent goes up.
Yes.
Okay, the amount that you're going to
That's
contribute.
right.
So it's rent stabilization for you. So if you want to come to this, the Manhattan Borough President's Office will be there too. It's sponsored by Helen Rosenthal. And we're out in about 3 seconds. Say goodbye.
Goodbye, all, and don't get on nationallibertyalliance.org and find out what
Bye.
your rights are and take power to back.